Hi. Hello. Hello, everyone. Yeah, good evening. Thank you for joining me. Sorry we started a bit late. It was technical issues. That's what happened. I'm sorry about that. Very sorry about that. Yeah, so we'll begin right now, and then we'll take it off from there. Thank you again for joining me. It's a pleasure to have you with me. Really, a great pleasure to have you with me. All right. Um, the whole essence of discussing, I think one of the inspiration for this meeting is that we should leave this meeting with a better understanding of what contract really is and how we can take advantage of that knowledge in making good decisions as with regard our businesses and regard um, everything we engage in, and that is very critical. Of course, you are aware of the controversy online about the proper contracts or not the proper contracts. So we intend to be able to do justice to that point. But I'll be upfront here. We'll take the conversation more like a conversation, one. Then two, I'm not going to try to impress you with any legal knowledge in that sense. So what I'm going to do essentially is to break it down as much as possible for everybody to understand. Yes. Um, some guys are having issues with their audio. Please indicate if you're not hearing me yet. Just let me know. I can see you in your chat section, in the chat sections there. Then I can know whether or not you're hearing me. Yeah. All right. So we're good. Okay. All right. So as I was saying, I said the whole. I'm not going to bore you with legal jargons because that's not necessary. You need to have a thorough understanding. So we need to begin from that point. From that point. So our introduction would be basically we'll have to look at um, some of the issues around contracts. And we are going to consider only two forms, really. We are going to consider two essential forms. And the first form will be basically, we need to consider what makes an agreement a contract, because that's important. What makes an agreement a contract, right? That's going to be important. What makes an agreement a contract is going to be important, right? And that supposes right now that not every agreement is a contract. So we'll discuss what makes an agreement a contract. That's first. Then two, we also discuss what form should a contract take, because that is very, very important. What form should a contract take? Yeah. So let's begin with an agreement to a contract. Let's begin with that. And I'll be sharing some. Let's begin with an agreement to a contract. What makes an agreement into a contract in law? The first, like you see there, is that it must satisfy what is called the elements of contract. There are certain things that the law has stipulated is the elements that if they are present in any agreement, that makes the agreement a contract. Those are called the elements. Then the second one is something I refer to as a deed. We will be explaining what that means as we go along. Just go with me, right? So the next point then we now need to um, emphasize then is what are these elements? What are the elements of a contract? Because that's important. What are the elements that makes a contract what it is? These are important. All right, there are basically three elements, right? One, it's offer, right? Two is acceptance, and the third one is consideration. So what is an offer? Colloquially, an offer just means these are the things I want you and I to agree on. That's what is called an offer. These are the things I want you and I to agree on. All right. So I send that to you and you accept it. That is called an acceptance. But we need to be careful here. When you say acceptance, Acceptance means I accept the terms, I accept your offer the way it is. If, for example, you send me an offer and say, AK, I want us to do so, so, and so, and I say, I accept it subject to my board ratifying it, that is not an acceptance, because that acceptance was not complete. It was, sorry, that acceptance was equivocal, right? I accepted it based on a condition. In other words, if my board gives approval, then I have accepted the offer, right? So that offer must be accepted, and it must be accepted in the terms in which it was made. If I modify that offer, it is no longer the same offer that you have. Let's not get a bit too technical now, right? Now, the third one is called consideration. What is consideration? We really should really understand this. For there to be a contract, even though there's an offer, there's an acceptance, there must be something that goes from the person accepting the contract, accepting the offer, to the person that is receiving the offer. And then there must be something that goes from the person receiving the offer to the person accepting the offer. What do I mean? What do I mean, really? Let me use it in a very straightforward way. What do I mean? This is what I mean. I speak to Femi. Femi is here. And I say, Femi, I want to buy your business at 20 million naira. You see, I want to buy his business at 20 million naira. Femi says, fantastic. I will sell my business to you at 20 million naira. What has happened is, so what am I giving Femi? I'm giving Femi 20 million. Femi is giving me his business. That is basically what consideration is. That is what consideration is. So, but if, for example, I say, okay, Femi, dash me your business. And Femi says, okay, Austin, I'll dash you your business. So he gives me his business. Nothing passed from me to him. So he can decide tomorrow, no, I take my business back. I take my business back. There was no contract because nothing moved from me to him. Now, this is where it's going to get a bit technical. Is there any particular price value that must be placed on, consideration? No. I can decide to say, Femi, I want to buy your business for 10 naira, right? But I want to buy Femi business for 10 naira, and Femi is willing to sell for me at 10 naira. Whether or not the business is worth 1 billion naira, but it sold it for me for 10 naira, is sufficient. Very sufficient. It's sufficient. And in law, that is a contract. Right? That is a contract. So when you hear all this controversy about we didn't buy it for the fair value, that's immaterial. The critical thing is something left me to the other person and something came from the other person to me. That's what consideration is. Right? So when you have these three elements, generally, when you have these three elements, you have an offer, you have an acceptance, and then you have a consideration, which you have defined, and which you have said that the value of the consideration is immaterial. You have what is called a contract. And that in itself is important. You have what is called a contract. Right? Let me use a typical example, because we are discussing in general terms what a contract is. We are not discussing in specific cases. We are looking at it generally. We may have a specific one that we will run, but we are discussing it generally, right? So let's use a typical example. Let me use this example. Say, I want to employ Tony, and I say, Tony, come and work for me, right? I will pay you 2 naira. You see what has happened at the end of every month? That is a contract. So what has happened? Tony works for me. That's what Tony is giving me as value. And I give Tony what? Money, exchange. That is consideration. Whether or not it's adequate, again, it's immaterial. Whether or not it's adequate, it's immaterial. All right. So that is the important part I wanted us to get on what constitutes, on what makes an agreement a contract. If you run through that checklist, you find out that a lot of the things we call contracts are not really contracts. And then that's where issues begin from, right? Okay, right. So what form should a contract take? What form should a contract take? Yeah, because that's, I found out is a major, major issue. What form should a contract take? Right. Okay, like I said here, a contract should takes two forms in law: tangible form and non-tangible. What do I mean tangible form? Where you can get to see the contract, you can see the paper, or you could see anything in which is written on. Then intangible form, where there is no form of the contract. And I do not, and I think you should know that. One of the ways in which a contract comes into being. So which one is non-tangible? Let me start from that. Which one is non-tangible? A non-tangible part means an oral agreement, right? A non-tangible form means oral, right? It means an oral agreement. And I hope that doesn't surprise you, right? When we say it means an oral agreement. Yeah, it shouldn't surprise you because you've seen a lot of it, haven't you? You should have seen a lot of it. Yeah, you should have seen much more, a lot of it. All right, so we say, okay, so a tangible, so non-tangible part of it is that it is oral. What are the characteristics of an oral agreement? Basically, an oral agreement means we agree on what the agreement is by words of our mouths. That's what we agree on. We agree by words of our mouths, right? So just like the example I was giving, so let's say roommate, for example, I say roommate, I want to come and work for me. I'll pay you 20 million naira every month, but you do so and so, right? Orally. So roommate says, okay, fine, Austin, I'll work for you. You pay me that. See, he has agreed to the terms. The danger in an oral agreement is, how do you prove that such and such agreement was made? How do you prove that? So most of the time we'll have issues with proving of that. How do you prove that such and such was made? Right? So we always have issues with that as we go along. But the tangible form of an agreement, which is where I want to put some weight tonight, is critical. The tangible forms mean the agreement is expressed in writing. It means the agreement is expressed in writing. Yeah, let me get the slide where I really emphasize that. I mean, it's expressed in writing, right? Yes. Let me see that. Where are you? Okay. Yes. It means it must be expressed in writing. And if you look at the slide, you notice I mentioned three types. I said one, it must be by deed. Two, it must be by the law. Three, by the choice of the parties. I'll explain that, but something just came to my mind. You know, when I was dealing with, I said there are two forms an agreement to take, and it's binding in law. And I said the first form is that it must intangible, not tangible. Let me explain to you what that means. There was a question I asked today on Twitter and on all my social media pages. I asked if does a contract require signing by both parties before it becomes binding? Now, if the law accepts an oral agreement, where are you going to sign? So every contract every contract do not require its signature for it to be binding. It does not require both parties to sign. Because if we make an oral agreement, it doesn't require any both of us to sign for it to become binding. So yes, so that answers your question. So yes, so just like you run a business, you call your supplier, you say, supplier, give me 20 so and so, I'll pay you in 15 days. And the supplier brings it. Most of the time, there's no oral agreement, there was no signed agreement before that comes, right? But yeah, that's enforceable in law. He can enforce that in law. All right, so let's go to the written types. There are basically three written types. One is by deed. Two is the agreement the law says must be written. And three, by the choice of the parties. In other words, there are three circumstances where you could get to write an agreement. Let me pause here and explain some things to you. This is what I want to explain. What you need to understand is that the general law guiding the way the law sees contract is this. There is something called the doctrine of freedom of contract. You must understand that. There's something called the doctrine of freedom of contract. What does that mean? That means you and I can decide to agree on anything. The law does not restrict us. We can agree on anything. The law does not restrict us. It's called the doctrine of freedom of contract. So, for example, like I was giving in the beginning, Femi can decide to sell his company valued at 40 million to me for 1 naira. It is our agreement. The court will not jump in and say, how could Femi sell that? And now I'm speaking generally. Of course, if it was found out Femi, okay, Femi, pardon me. If it was found out Femi's was not at that stage saying that affects the validity of that contract. But assuming everything is equal, the law will not affect that. You know the controversy about the one going around online and whether or not the contract was fair. The law is not concerned with the fairness of a contract. What the law is concerned with is that the contract, that there was 3 things. There was offer, there was acceptance of the terms, and then there was consideration. Now, I need you to always have that in mind anytime you are contracting, that the law is not concerned with the fairness of the law. Right. I needed to get that out of the way. All right. So we are discussing the 3 types of written contract, or the 3 types where the form of contract must be in writing. And I think I was saying something about yeah, let me see. I need to get my slide back on. Okay, I was saying by deed. Please pay attention. A contract by deed implies that it has a certain form it must follow. There's a form of contract called deed. I can't show you an example now, but I'm going to forward it to you to just show you some of the example of what a deed is. When a contract is by deed, you do not need to furnish consideration. I need you to get that. Say, for example, Femi wants to dash me his company, right? See, I am not paying Femi anything, so no consideration is coming from me. That contract must be by deed. The only time a contract like that will be enforced, it is when it is by deed. In other words, when there's no consideration in a contract, you must draft it by deed. Learn that and learn that and learn that for all time. What I do most of the time, if I'm not sure that there's adequate, consideration, or that there's no consideration, what I do most of the time is I draft it by deed, no matter the nature of the contract, right? Then the second one is by law. There are some contracts the law states must be in writing, whether or not you like it. In other words, if it is not in writing, you can't enforce it in contract. There are certain laws, there are certain contracts the law states must be in writing. I'm going to explain that, so let me leave that. The third one is by the choice of the party. 2 of you decide that you must put your contract in writing. And I think that's, for me, when I advise people, I always say you should put your contract in writing. So the question most people would like to ask, what form? Do we need to get a lawyer? Of course, you should get a lawyer. But can you and I draft a contract? Assuming I'm not a lawyer, you are not a lawyer. Can 2 of us draft a contract? Of course. I've stated already what the 3 what the 3 elements of a contract is. As long as that 3 elements are there, we have a valid contract, right? So what are those contracts that the law requires must be in writing? What are those contracts? Let's deal with that. Hey, okay, I hope I find it. Writing types. Just a minute, guys. Okay. Yeah, by the law. What form? Yeah, that's it. I've seen it here. Yeah, by the law. This is it. These are the contract that must be in writing. Number 1, contract that will not be performed within a year. So I sign into that. You and I agree on that contract, right? But that contract will be performed. Today is 27. That contract will be performed by December 2021. That contract must be in writing, or else nobody can enforce it. I know you get that. Sounds strange. Then the second one is guarantee agreements. When someone says, come and guarantee, we have the typical example. If you're a software guy here or you're working in a big company, or when you run some transaction, you say, I need a guarantor. That contract where someone guarantees another person must be in writing. Must be. Then, of course, this one, sale of land. That's compulsory. Or any transfer of interest in it must be. Transfer of interest means you want to mortgage or you want to do some other things. It must be in writing. Then this fourth one, I'm just going to pretend like it's not important. But what the law says is that when you sell goods worth over 10 pounds, as at that time, so we have to get the equivalent in Naira right now, it must be in writing. So it must be in writing. So you're wondering, okay, so how are we going to do it? How are we going to do it? I'm going to shock you with the next presentation, which how then should your contract be in writing? Because that is important. What form of writing should it take? What form of writing should it take? What form of writing should it take? Yeah, because that's where a lot of people get into trouble. What form of writing should it take? All right, just see the slide and you'll be shocked. Any form. Have you seen that? The contract can take any form. Absolutely any form. What do I mean any form? I'll give you an example. The contract can take any form. The writing can take care of any form. What do I mean any form? You and I can sit down and scrabble on a piece of paper and say, and we'll scribble on it, and that's a contract in law. As long as those three elements are there: offer, acceptance, consideration. You and I, you can tear a piece of paper and write the contract on it. As long as those three elements are there, that contract is enforceable in law. Another example, listen, the underlying word is that it must be in writing. So any contract that has to be in writing can be written in that form. It can be written in that form, in any form. So what of email? Of course, we can contract basically on what's an email, on what's on an email. Yeah, we exchange email, we exchange the offer, and then we accept based on email. That is a valid contract in law. So the form of writing is not important. The form of writing is not important. The important thing is, if the law states that the contract must be in writing, it must be in writing. The law does not state the form of writing in which it must be in. I'll give you a very funny example. There are some cases in law where a lawyer wrote a letter on behalf of his clients. Inside that letter, it was found that he stated the nature of the contract between his client and another person. And that was regarded in law as a contract. Yeah, Japa, I just saw that. Yeah. That was from colonial era. We'll do a webinar on what's on our archaic laws and what we should do about it. All right. So any form of writing. Let me give you another typical example. We could just take a piece of paper. I'm trying to look for a piece of paper and just write, and that becomes a contract, as long as it has those three key parts. So that's the point I need you to get. You need to understand that. What does that mean? That means, I know some lawyers will shout, but that means, really, you do not require a lawyer to draft a contract. Listen to my words, I'm choosing it carefully. But you need a lawyer if you need to understand the terms and put it in perfect play. Let me explain what I mean before I'm misquoted. A lawyer is not compulsory to draft a contract between you and another person. A lawyer is not required. But you are advised to have a lawyer that you should consider so that you don't get stuck up on form. So just basically, for example, have an urgent matter, you have an urgent matter to attend to right now. You do not have the time and energy to you need to close. You could put in a bit of paper. So what are the things that should be in that piece of paper? There are basically three things that must be in that piece of paper. And I think you know what they are already. Number one, I think I have a slide to that effect. Number one, let me get it so that you see it. Writing types, what form to take. Okay. Oh, well, I don't know what happened to it. Somebody probably took it. Okay. But number one, what form of, what must be in that form in writing? Number one is this, right? Number one is, first, the parties to the contract must be stated therein. Who are the parties? You must state who are the parties contracting and what is their, in what way are they contracting. You must state that. That's one. Number two, you must state what the subject matter of the contract is. That's two. You must state what the subject matter of the contract is. That's number two. Then number three, it must state what the consideration, what we call, like I think I've explained that already, what we call consideration, it must contain it. So let's take a typical example right now. I say I am Jakpa. Jakpa is a software guy. Jakpa is a hardware guy. All right. And I say, Jakpa, develop this hardware for me, so and so. And with two of us is there. So this is the form. If we sit down and write this contract and say, I, Augustine Ngwu, agrees with Jakpa, so and so, for Jakpa to develop so and so hardware for me within so and so days. Bam, that's an agreement. And he signs and I sign. The important thing in contracting writing is that it should be signed. I'm going to go back. Actually, what the law says is that the person you want to take to court must have signed the agreement. So it doesn't necessarily require that both of you must sign the agreement. But what it requires is that the agreement, the person you are taking to court must have signed that agreement. And there are reasons for that, but it's beyond the scope of this discussion right now. Right. Okay. So that paper that I and Jakpa have written is basically, it's actually an agreement that can be enforced in law. So the question is, what is signature, really? You know, I love this part. What is signature? Signature does not mean you now have to draw some very hieroglyphic sign. No. In several decisions, just inscription of your name becomes a signature. For example, I'm going to have a webinar on electronic contracts. I hope you join me for that. But let's say, for example, we exchange mails, I and Jakpa exchange mails. How is it going to be signed? Sometimes it might be signed by digital signature, yes. But sometimes it might just be my name and I put Austin Ngwu on that. And that in itself becomes a valid agreement. Yes. So that's the point I wanted to share. This is just a preliminary discussion around what contract is. There are two other core points we should have discussed, but we do not have the space and time to write right now. One is the terms of the contract and how a contract will end. Hopefully you join me in discussing that when I put up that for discussion. Yes. So that's our discussion for tonight. That's our discussion for tonight. But I appreciate it if you join me on any of my channels. It's there on the screen, on LinkedIn, on Insta, on Twitter. I'm doing a lot on Twitter, and then on my YouTube page. This video will, of course, be on the YouTube page. And we'll have a lot of this way so that we can reach you, and then we can all share our experiences in accordance with the law. I'll conclude with this. You need an understanding. There's something I say. I say there's no, the law is not separate from business, and the law is not separate from life. The three of them are integral. You need to have a better understanding of the law to be able to operate in life and in business. And my goal, my responsibility is to ensure that keeps getting done. Thank you so much. If you have a question, I think we still have some time. Yes, we still have about 10 minutes. I just wanted to take this for now. We still have some. Thank you, Sylvia. Thank you so much. We need to take some time. I have about 10 minutes. What you do for me, could you either send your question in the group platform? We created a group platform for everybody that participated. Can you send your question there, and then we'll take it up from there, and we answer those questions. Thank you so much. Yeah. Yes, Jakpa is from Delta. Yes, he is from Delta. Yes, thank you so much. But we have about 10 minutes or 8 or 9 minutes to go. If you have some questions, just ask, and then I'll be able to answer them in the next 2-3 minutes. I will go. Wow, Sylvia asks, how do you handle a client who breaches an agreement? Wow. I intend to break this into series. So by next week, I'm going to have 2 discussions. We're going to have 2 webinars on that, on fundamental parts of a contract and what happens when somebody breaches it. But I'll just tell you straightforward. I agree that is, okay, she has modified her question. She says, how do you handle a client who breaches an agreement, even though they're aware no written agreement. If you remember what I said, it's advisable to already have written agreement. The question then becomes, Xavier, how do you prove the things that was agreed in that agreement? How do you prove them? That's the issue. If you can have witnesses that can prove them, fine, but that's going to be a problem. There are no proof, you're in trouble. There's no way you can deal with that client. You're in trouble if there's no proof. Yeah. 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 So I've attended to that. If it's just one-on-one, you're in trouble. You're in major trouble. I don't like to be in your shoe. I don't like to be the lawyer advising you, but you are in trouble. Yes. All right, guys. I hope you've enjoyed this section, really. I've had fun talking to you. Hopefully, and I trust you'd have gained some amazing things from all the stuff. Hopefully, you'd have gained some amazing insight from the discussions we've had, right? Yes. Yeah. Yeah. Thank you so much for joining me tonight. Thank you so much. So we'll do this again next week, hopefully. I'll send you the link for our next webinar, and then we could take the discussion further. Thank you. Thank you.